Welcome to this exam review from Birdsey, your AI-powered study partner. Be sure to like and subscribe for more videos, and don't miss what's happening in the lower corner of the screen. It could be just the thing you need to pass your exam. Let's get started.
Let's start with a look at California agency law and mandatory disclosures. Dual agency and CA disclosure rules. What is required for a dual agency relationship to be legally established in California? Is it A, verbal agreement from both parties? B, approval from the California Department of Real Estate? C, informed written consent from both parties? Or D, a signed affidavit by the agent? The answer is C, informed written consent from both parties. In California, dual agency requires informed written consent from both parties involved in the transaction. This ensures that both parties are aware of the dual representation and agree to it. In a dual agency situation, what must an agent disclose to both parties? Is it A, the commission structure? B, their dual agency status? C, the property's market value? Or D, the seller's minimum price? The answer is B, their dual agency status. Why this question may seem a bit tricky, the agent must disclose their dual agency status and obtain written consent, not just disclose the property details or commission structure. Agent Smith represents both the buyer and seller in a transaction. What must Agent Smith do to comply with California's dual agency rules? Is it A, obtain informed written consent from both parties? B, ensure both parties agree verbally? C, provide a copy of the agency agreement to the California Department of Real Estate? Or D, disclose the dual agency only to the seller? The answer is A, obtain informed written consent from both parties. Agent Smith must obtain informed written consent from both the buyer and seller to comply with California's dual agency rules. What is the primary risk associated with dual agency in real estate transactions? Is it A, increased commission fees? B, delayed closing process? C, inaccurate property valuation? Or D, conflict of interest? The answer is D, conflict of interest. The primary risk of dual agency is the potential conflict of interest, as the agent represents both parties with potentially opposing interests. During a dual agency transaction, the buyer asks Agent Lee for the seller's bottom line price. What should Agent Lee do? Is it A, disclose the seller's bottom line price? B, ignore the buyer's question? C, maintain confidentiality and not disclose the price? Or D, ask the seller for permission to disclose the price? The answer is C, maintain confidentiality and not disclose the price. Agent Lee should maintain confidentiality and not disclose the seller's bottom line price, as it would breach fiduciary duties. Agent Kim is representing both the buyer and seller in a real estate transaction in California. The buyer asks Kim if the seller is willing to accept a lower offer. What should Kim do to comply with dual agency rules? Is it A, disclose the seller's bottom line to the buyer? B, encourage the buyer to make a higher offer? C, inform the buyer that such information is confidential? Or D, ask the seller if they want to disclose their bottom line? The answer is C, inform the buyer that such information is confidential. In a dual agency, the agent must maintain confidentiality and cannot disclose confidential information, like the seller's willingness to accept a lower offer without explicit consent.
Have you noticed the code in the bottom corner? Next time you're stumped, take that code to birdsey.ai for immediate help and a free study session with Birdsey, your personal AI study partner. Plus, you'll get access to hundreds of additional questions, helping you move closer to passing your exam with confidence. The next time you're feeling unsure or stuck, give it a try.
TDS, NHD, and hazard zone disclosures. What is the primary purpose of the transfer disclosure statement in California real estate transactions? Is it A, to provide a valuation of the property? B, to disclose known defects and conditions of the property? C, to outline the terms of the sale agreement? Or D, to guarantee the property is free of hazards? The answer is B, to disclose known defects and conditions of the property. The TDS is designed to inform buyers of the condition of the property and any known defects, ensuring transparency and reducing the risk of disputes. Which of the following is not required to be disclosed in a natural hazard disclosure statement? Is it A, flood zone status? B, earthquake fault zones? C, proximity to a landfill? Or D, fire hazard severity zones? The answer is C, proximity to a landfill. Why this question may seem a bit tricky, the NHD focuses on natural hazards like flood zones, not man-made hazards such as nearby landfills. John is selling his house and knows about a leaky roof but doesn't mention it in the TDS. What is the potential consequence of this omission? Is it A, the buyer may sue for misrepresentation? B, the sale will automatically be voided? C, the buyer must accept the property as is? Or D, the seller can adjust the sale price post-closing? The answer is A, the buyer may sue for misrepresentation. Failing to disclose known defects like a leaky roof can lead to legal action for misrepresentation or fraud by the buyer. Which document is used to disclose the presence of lead-based paint in a property built before 1978? Is it A, transfer disclosure statement? B, natural hazard disclosure? C, seller's affidavit? Or D, lead-based paint disclosure? The answer is D, lead-based paint disclosure. The lead-based paint disclosure is required for properties built before 1978 to inform buyers of potential lead hazards. Emily is buying a home in a designated flood zone but was not informed by the seller. What should Emily do upon discovering this omission? Is it A, accept the risk and proceed with the purchase? B, request a reduction in the sale price? C, consult a real estate attorney for legal options? Or D, cancel the transaction without penalty? The answer is C, consult a real estate attorney for legal options. Emily should consult a real estate attorney to explore legal remedies, as the seller is required to disclose such information. Fiduciary duties and misrepresentation. What is the primary fiduciary duty of a real estate agent to their client under California law? Is it A, confidentiality? B, loyalty? C, disclosure? Or D, obedience? The answer is B, loyalty. The primary fiduciary duty of a real estate agent is loyalty, ensuring the client's interests are prioritized above all else. Under California law, can a real estate agent disclose confidential client information if it benefits the client? Is it A, yes, if it benefits the client? B, yes, if the agent believes it's in the client's best interest? C, no, unless the client consents or it's legally required? Or D, no, under any circumstances? The answer is C, no, unless the client consents or it's legally required. Why this question may seem a bit tricky. Confidentiality is absolute unless the client consents to disclosure or it's legally required, regardless of perceived benefit. A seller's agent discovers a defect in the property that the seller did not disclose. What should the agent do according to California fiduciary duties? Is it A, disclose the defect to potential buyers? B, keep the defect confidential to protect the seller? C. Advise the seller to fix the defect without disclosure. Or D. Ignore the defect as it's the seller's responsibility. The answer is A. Disclose the defect to potential buyers. The agent must disclose known defects to potential buyers to fulfill their duty of disclosure and honesty. During a property showing, a buyer's agent learns from a neighbor about a planned nearby development. What should the agent do? Is it A. Ignore the information as it's not confirmed? B. Only disclose if the buyer asks about future developments? C. Verify the information before disclosing? Or D. Disclose the information to the buyer? The answer is D. Disclose the information to the buyer. The agent should inform the buyer about the development as it may affect the property's value or desirability.
Finding this exam review helpful? If you haven't already, like and subscribe for more videos that'll get you ready to pass.
Let's continue with property characteristics, land use controls, and California regulations. Subdivision Map Act and CEQA. What is the primary purpose of the Subdivision Map Act in California? Is it A. To regulate the division of land into smaller parcels? B. To enforce environmental protection measures? C. To control property taxes? Or D. To manage residential zoning laws? The answer is A. To regulate the division of land into smaller parcels. The Subdivision Map Act primarily regulates the division of land into smaller parcels to ensure orderly development and infrastructure planning. Under CEQA, what is an environmental impact report primarily used for? Is it A. To approve construction permits? B. To determine property boundaries? C. To assess environmental impacts of a project? Or D. To enforce zoning compliance? The answer is C. To assess environmental impacts of a project. An EIR is used to assess the potential environmental impacts of a proposed project and suggest mitigation measures. A developer plans to build a new housing complex. They submit an initial study under CEQA. What is the purpose of this document? Is it A. To finalize project approval? B. To determine if an EIR is necessary? C. To outline construction timelines? Or D. To allocate funding for environmental mitigation? The answer is B. To determine if an EIR is necessary. Why this question may seem a bit tricky. An initial study is often confused with an EIR, but it determines if an EIR is necessary by assessing potential impacts. If a city planner is reviewing a proposed subdivision plan under the Subdivision Map Act, what is their primary concern? Is it A. Ensuring the project has minimal environmental impact? B. Maximizing the developer's profit? C. Approving the architectural design? Or D. Compliance with local ordinances and infrastructure needs? The answer is D. Compliance with local ordinances and infrastructure needs. Why this question may seem a bit tricky. The planner's main focus is on ensuring the subdivision complies with local ordinances and infrastructure needs, not just environmental impacts. A real estate developer is considering a project near a protected wetland. According to CEQA, what should they do first to ensure compliance? Is it A. Conduct an initial study? B. Apply for a zoning variance? C. Submit a final project plan? Or D. Request a building permit? The answer is A. Conduct an initial study. The developer should conduct an initial study to determine the environmental impacts and whether an EIR is needed. Zoning and Coastal Commission Authority. What is the primary purpose of zoning laws in California? Is it A. To increase property taxes? B. To regulate land use and ensure community safety? C. To provide funding for public schools? Or D. To control the architectural style of buildings? The answer is B, to regulate land use and ensure community safety. Zoning laws are designed to regulate land use and ensure that land is used in a way that is consistent with community goals and safety standards. Which entity has the authority to enforce coastal development permits in California? Is it A, local city councils, B, the Environmental Protection Agency, C, the California Coastal Commission, or D, the Department of Housing and Urban Development? The answer is C, the California Coastal Commission. Why this question may seem a bit tricky. The California Coastal Commission is often confused with local governments, but it holds the primary authority over coastal development permits. A developer plans to build a new hotel on the California coast. What must they obtain to proceed legally? Is it A, a coastal development permit from the California Coastal Commission, B, a zoning variance from the local city council, C, an environmental impact report from the EPA, or D, a building permit from the State Housing Authority? The answer is A, a coastal development permit from the California Coastal Commission. The developer must obtain a coastal development permit from the California Coastal Commission to ensure compliance with coastal regulations. Mello-Roos and special assessments. What is the primary purpose of a Mello-Roos Community Facilities District? Is it A, to regulate zoning laws in a community, B, to finance public infrastructure and services, C, to enforce environmental protection regulations, or D, to support private development projects? The answer is B, to finance public infrastructure and services. Mello-Roos CFDs are created to finance public infrastructure and services through special taxes. They are not primarily for zoning, environmental protection, or private development. Which of the following is not a characteristic of a Mello-Roos tax? Is it A, it is a special tax levied in addition to property taxes, B, the amount can vary from year to year, C, it is based on the assessed value of the property, or D, it funds public infrastructure projects? The answer is C, it is based on the assessed value of the property. Why this question may seem a bit tricky. Mello-Roos taxes are often confused with regular property taxes, but they are special taxes that can vary annually and are not based on property value. A homeowner in a Mello-Roos district is selling their property. What must they disclose to potential buyers? Is it A, the existence of Mello-Roos taxes on the property, B, the specific projects funded by the Mello-Roos taxes, C, the history of tax rate changes in the district, or D, the original vote that established the Mello-Roos district? The answer is A, the existence of Mello-Roos taxes on the property. Sellers must disclose the existence of Mello-Roos taxes to potential buyers, as these are additional financial obligations that affect property ownership. Environmental hazards and remediation. What is the primary purpose of a zoning ordinance in land use control? Is it A, to increase property taxes, B, to regulate land use and development, C, to provide public utilities, or D, to enforce building codes? The answer is B, to regulate land use and development. Zoning ordinances are designed to regulate land use and ensure that land is used in a way that is consistent with community goals and plans. Which of the following is not considered an environmental hazard that requires disclosure in California real estate transactions? Is it A, mold, B, lead-based paint, C, radon, or D, asbestos? The answer is C, radon. Why this question may seem a bit tricky. Mold, lead-based paint, and asbestos are well-known hazards requiring disclosure. Radon, while a hazard, is not specifically mandated for disclosure in California. A homeowner in California discovers an underground storage tank on their property. What is the first step they should take to address this environmental hazard? Is it A, report the discovery to the local environmental agency? B, attempt to remove the tank themselves? C, ignore it if there are no immediate leaks? Or D, sell the property without disclosing the tank? The answer is A, report the discovery to the local environmental agency. The homeowner should first report the discovery to the local environmental agency to assess the situation and determine the necessary remediation steps. In California, which of the following statements about the Coastal Zone Conservation Act is incorrect? Is it A, it aims to protect coastal resources? B, it regulates development in coastal areas? C, it requires permits for certain coastal activities? Or D, it promotes industrial development in coastal zones? The answer is D, it promotes industrial development in coastal zones. Why this question may seem a bit tricky. The Coastal Zone Conservation Act aims to protect coastal resources, not to promote industrial development, which is contrary to its conservation goals.
Finding this exam review helpful? If you haven't already, like and subscribe for more videos that'll get you ready to pass.
Let's move on to contracts, escrow, and California transaction procedures. CA purchase agreements and contingencies. What is the primary purpose of a contingency in a California purchase agreement? Is it A, to ensure the buyer pays a higher price? B, to allow contract cancellation if conditions aren't met? C, to guarantee the seller a backup offer? Or D, to expedite the closing process? The answer is B, to allow contract cancellation if conditions aren't met. Contingencies protect parties by allowing them to cancel the contract if certain conditions are not met, such as financing or inspections. In a California purchase agreement, what happens if a buyer fails to remove a contingency by the deadline? Is it A, a contract automatically cancels? B, the buyer loses their deposit? C, the seller can issue a notice to perform? Or D, the buyer must renegotiate terms? The answer is C, the seller can issue a notice to perform. Why this question may seem a bit tricky. The buyer's failure to act might suggest automatic cancellation, but it actually allows the seller to issue a notice to perform or cancel the contract. John is buying a house in California and discovers a major plumbing issue during inspection. What should he do according to the purchase agreement contingencies? Is it A, request repairs or a price reduction? B, ignore the issue and proceed? C, cancel the contract immediately? Or D, wait until closing to address it? The answer is A, request repairs or a price reduction. John should request repairs or a price reduction as contingencies allow, addressing issues found during inspections. Lisa is selling her home and receives an offer with a financing contingency. What should she consider before accepting? Is it A, the buyer's offer price? B, the closing timeline? C, the condition of the property? Or D, the buyer's financial stability? The answer is D, the buyer's financial stability. Lisa should consider the buyer's financial stability as the contingency allows them to back out if financing fails. Escrow process and closing practices. What is the primary purpose of an escrow in a real estate transaction? Is it A, to provide legal advice to the buyer and seller? B, to ensure all conditions of the transaction are met before closing? C, to determine the market value of the property? Or D, to negotiate terms between the buyer and seller? The answer is B, to ensure all conditions of the transaction are met before closing. The primary purpose of an escrow is to ensure that all conditions of a real estate transaction are met before the property and funds are transferred between parties. In California, who is typically responsible for selecting the escrow company in a real estate transaction? Is it A, the seller unilaterally selects the escrow company? B, the real estate agent selects the escrow company? C, the decision is negotiated between the buyer and seller? Or D, the lender selects the escrow company? The answer is C. The decision is negotiated between the buyer and seller. Why this question may seem a bit tricky. While it is common for the buyer to suggest an escrow company, the decision is often negotiated and agreed upon by both parties. During a real estate transaction in California, Maria, the buyer, discovers a lien on the property after escrow has opened. What should be the next step to ensure a smooth closing? Is it A, the escrow agent should work with the seller to resolve the lien? B, Maria should immediately cancel the transaction? C, the seller should ignore the lien, as it will not affect the closing? Or D, Maria should pay off the lien to expedite the process? The answer is A, the escrow agent should work with the seller to resolve the lien. The escrow agent should work with the seller to resolve the lien before closing, ensuring all title issues are cleared. John is selling his home in California, and the buyer has requested an extension on the escrow closing date. What should John consider before agreeing? Is it A, the buyer's reason for the extension is irrelevant? B, the extension will automatically benefit John? C, John should agree without any conditions? Or D, the impact on John's future plans and potential costs? The answer is D, the impact on John's future plans and potential costs. John should consider the impact on his plans and any potential costs or risks associated with the extension. CA Landlord-Tenant Rules. Under California law, what is the maximum security deposit a landlord can charge for an unfurnished residential property? Is it A, 1 month's rent? B, 2 months' rent? C, 3 months' rent? Or D, 4 months' rent? The answer is B, 2 months' rent. California law limits the security deposit for an unfurnished residential property to 2 months' rent. This is to protect tenants from excessive upfront costs. Jessica, a tenant in California, notices mold in her apartment and informs her landlord. The landlord does not address the issue. What is Jessica's best course of action under California law? Is it A, immediately stop paying rent without notice? B, move out and terminate the lease immediately? C, withhold rent after giving the landlord a reasonable time to fix the issue? Or D, file a lawsuit against the landlord immediately? The answer is C, withhold rent after giving the landlord a reasonable time to fix the issue. Jessica can withhold rent if the landlord fails to maintain the property in a habitable condition, but she must follow legal procedures to do so. Now let's review California real estate finance and lending laws. Mortgage brokerage law. What is the primary purpose of the California mortgage brokerage law? Is it A, to regulate mortgage broker activities to protect consumers? B, to set interest rates for mortgage loans? C, to provide tax incentives for home buyers? Or D, to establish real estate agent licensing requirements? The answer is A, to regulate mortgage broker activities to protect consumers. The California mortgage brokerage law primarily aims to regulate the activities of mortgage brokers to protect consumers from unethical practices. Under the California mortgage brokerage law, who is primarily responsible for ensuring that a borrower understands the terms of a mortgage loan? Is it A, the borrower? B, the mortgage broker? C, the lender? Or D, the real estate agent? The answer is B, the mortgage broker. Why this question may seem a bit tricky. It might seem like the borrower is responsible, but the law places the onus on the broker to ensure understanding. A mortgage broker in California fails to disclose a conflict of interest to a client. What is the likely consequence under the mortgage brokerage law? Is it A, the client can sue for damages? B, the broker must refund all fees? C, the broker may face fines or license suspension? Or D, the transaction is automatically voided? The answer is C. The broker may face fines or license suspension. Failure to disclose conflicts of interest can lead to penalties, including fines or suspension of the broker's license. Which entity enforces the California mortgage brokerage law? Is it A, Federal Trade Commission? B, California State Legislature? C, Consumer Financial Protection Bureau? Or D, California Department of Real Estate? The answer is D, California Department of Real Estate. The California Department of Real Estate is responsible for enforcing the mortgage brokerage law. If a borrower in California believes their mortgage broker has violated the mortgage brokerage law, what is their first step? Is it A, file a complaint with the California Department of Real Estate? B, contact the Federal Reserve? C, sue the broker in small claims court? Or D, report to the Better Business Bureau? The answer is A, file a complaint with the California Department of Real Estate. The borrower should file a complaint with the California Department of Real Estate, which oversees broker conduct. Foreclosure procedures. What is the primary purpose of a notice of default in California's foreclosure process? Is it A, to immediately repossess the property? B, to inform the borrower of their default status? C, to finalize the foreclosure sale? Or D, to offer a loan modification? The answer is B, to inform the borrower of their default status. The notice of default serves as the official notification to the borrower that they are in default and initiates the foreclosure process. In California, how long must a lender wait after filing a notice of default before scheduling a foreclosure sale? Is it A, 30 days? B, 60 days? C, 90 days? Or D, 120 days? The answer is C, 90 days. Why this question may seem a bit tricky, the timeline involves multiple steps, and the 90-day period is specific to the waiting period after the notice of default, not the entire foreclosure process. John received a notice of default on his California home loan. If he wants to stop the foreclosure process, what is the most effective action he can take? Is it A, reinstate the loan by paying the overdue amount? B, file for bankruptcy immediately? C, ignore the notice and wait for further action? Or D, request a loan modification? The answer is A, reinstate the loan by paying the overdue amount. Reinstating the loan by paying the overdue amount is the most direct way to stop the foreclosure process. What is the minimum time period between a notice of trustee sale and the actual sale date in California? Is it A, 7 days? B, 14 days? C, 30 days? Or D, 21 days? The answer is D, 21 days. The minimum time period is 21 days, which allows the borrower time to take action before the sale. Maria is facing foreclosure on her California property and wants to know if she can redeem her property after the foreclosure sale. What should she be aware of? Is it A, she can redeem the property within 6 months after the sale? B, there is no redemption period after a non-judicial foreclosure sale? C, she can redeem the property if she pays the full sale price within 30 days? Or D, she can negotiate with the new owner to buy back the property? The answer is B, there is no redemption period after a non-judicial foreclosure sale. In California, there is no statutory right of redemption after a non-judicial foreclosure sale. Property tax rules. What is the maximum annual increase in assessed property value allowed under California's Proposition 13? Is it A, 1%, B, 2%, C, 3%, or D, 5%? The answer is B, 2%. Proposition 13 limits the annual increase in assessed property value to 2% unless the property changes ownership or undergoes new construction. Under Proposition 19, which of the following scenarios allows a homeowner to transfer their tax assessment to a new home? Is it A, any homeowner moving within California, B, homeowners moving to a more expensive home, C, homeowners over 55 moving within California, or D, homeowners moving to a less expensive home? The answer is C, homeowners over 55 moving within California. Why this question may seem a bit tricky, Proposition 19 allows homeowners over 55, severely disabled, or victims of a natural disaster to transfer their tax assessment, not just any homeowner. Maria, a 60-year-old homeowner in California, decides to sell her home and buy a new one in the same county. Under Proposition 19, can she transfer her property tax assessment to the new home? Is it A, yes, because she is over 55 and moving within the same county? B, no, because she is moving to a new property? C, no, because the new home is in the same county? Or D, yes, but only if the new home is less expensive? The answer is A, yes, because she is over 55 and moving within the same county. Maria is over 55, which makes her eligible to transfer her property tax assessment under Proposition 19. Which of the following is a primary feature of California's Proposition 13? Is it A, allows unlimited property tax increases, B, caps property tax rates at 2%, C, allows reassessment upon sale of property only, or D, limits property tax rates to 1% of assessed value? The answer is D, limits property tax rates to 1% of assessed value. Proposition 13 primarily limits property tax rates to 1% of the assessed value and caps annual increases in assessed value. John, who is severely disabled, sells his home and buys a new one in a different county in California. Can he transfer his property tax assessment under Proposition 19? Is it A, no, because he's moving to a different county? B, yes, because he is severely disabled? C, no, because the new home is more expensive? Or D, yes, but only if the new home is less expensive? The answer is B, yes, because he is severely disabled. John qualifies to transfer his property tax assessment because Proposition 19 allows this for severely disabled individuals. Lastly, let's take a look at ownership, transfer, and title matters in California. Ownership forms and vesting. What is the primary characteristic of joint tenancy in California? Is it A, tenants can sell their interest without consent? B, right of survivorship? C, each tenant owns an unequal share? Or D, tenants can will their interest to heirs? The answer is B, right of survivorship. Joint tenancy in California is characterized by the right of survivorship, meaning that when one joint tenant dies, their interest automatically passes to the surviving joint tenants. In California, which form of ownership allows a married couple to own property with the right of survivorship but also allows for separate interests? Is it A, tenancy in common? B, joint tenancy? C, community property with right of survivorship? Or D, community property? The answer is C, community property with right of survivorship. Why this question may seem a bit tricky. Community property with right of survivorship is often confused with joint tenancy, but it specifically applies to married couples and allows for separate interests. Sarah and Tom, a married couple, want to ensure that their property automatically transfers to the surviving spouse upon death without going through probate. Which form of ownership should they choose? Is it A, tenancy in common, B, joint tenancy, C, community property, or D, community property with right of survivorship? The answer is D, community property with right of survivorship. Community property with right of survivorship allows property to automatically transfer to the surviving spouse without probate, making it ideal for Sarah and Tom's needs. Alex and Jamie, who are not married, want to purchase a property together in California and ensure that each can pass their share to their heirs. What form of ownership should they choose? Is it A, tenancy in common, B, joint tenancy, C, community property, or D, community property with right of survivorship? The answer is A, tenancy in common. Tenancy in common allows each owner to pass their share to heirs, making it suitable for Alex and Jamie's situation. Deeds, recording, and homestead. What is the primary purpose of recording a deed in California? Is it A, to validate the deed, B, to guarantee the title, C, to provide public notice of ownership, or D, to transfer ownership? The answer is C, to provide public notice of ownership. Recording a deed provides public notice of ownership, establishing priority over unrecorded interests. It does not validate the deed or guarantee title. In California, which type of deed offers the greatest protection to the grantee? Is it A, general warranty deed, B, quitclaim deed, C, bargain and sale deed, or D, grant deed? The answer is A, general warranty deed. Why this question may seem a bit tricky. The term greatest protection might mislead some to think of insurance or guarantees, but it refers to the covenants provided by the deed. Maria sold her house to John, but the deed was never recorded. Later, Maria sold the same house to Lisa, who recorded her deed. Who has legal ownership of the house in California? Is it A, John because he purchased the house first, B, Maria because she sold the house twice, C, both John and Lisa as they both have claims, or D, Lisa because she recorded her deed? The answer is D, Lisa because she recorded her deed. In California, the first to record a deed generally has priority. Since Lisa recorded her deed, she has legal ownership despite the prior sale to John. Water, mineral, and easement rights. In California, who typically holds the mineral rights to a property unless explicitly stated otherwise in the deed? Is it A, the property owner, B, the state government, C, the federal government, or D, the previous owner? The answer is A, the property owner. In California, mineral rights are typically held by the property owner, unless the deed specifies otherwise. This means the owner has the right to extract minerals from the land. A property owner in California discovers water on their land. What is the most accurate statement regarding their rights to use this water? Is it A, they have unlimited rights to use the water as they see fit, B, they must apply for a permit to use any water found on their property, C, they may have riparian rights if the water is part of a natural watercourse, or D, they can sell the water rights separately from the land? The answer is C, they may have riparian rights if the water is part of a natural watercourse. Why this question may seem a bit tricky. California follows a complex system of water rights, including riparian and appropriative rights. Simply owning land does not guarantee unrestricted water use. John owns a property in California with an easement allowing his neighbor to use a path across his land. If John sells his property, what happens to the easement? Is it A, the easement is terminated upon sale? B, the easement remains in effect for the new owner? C, the new owner can revoke the easement at their discretion? Or D, the neighbor must renegotiate the easement with the new owner? The answer is B. The easement remains in effect for the new owner. Easements typically run with the land, meaning they remain in effect even if the property is sold, benefiting the holder of the easement.
Thanks for watching. If you found this exam review helpful, be sure to subscribe for more real-world practice and topic-focused study videos. And visit birdsey.ai to start your free trial of Birdsey, your AI-powered study partner.